Hi, my name is Gennady, and I'm an attorney with the law officer Yuri Moshes. Today, I'm going to discuss employment discrimination on the basis of criminal records. Illegal employment discrimination on the basis of criminal convictions is more common in New York than many want to believe. For those with criminal records, especially felony records, reintegration into society can be very difficult. People with prior convictions have difficulty in restoring their civil rights to vote and carry firearms, among other rights. However, often the most difficult facet of the prior felony conviction to overcome is the criminal stigma, especially in the job market. Now, what is a criminal conviction? A person with a criminal conviction is someone who has been convicted of either a misdemeanor or a felony. Simply because someone has been arrested does not necessarily imply that the arrested individual committed any crime. Many arrests never result in a conviction. New York law forbids criminal conviction discrimination. Under New York law, an employer cannot deny you a job or terminate your employment due to an arrest if you have not been convicted. Specifically, the New York State Human Rights Law and the New York City Human Rights Law prohibit employers from denying an individual a job because of any arrest that did not result in a conviction, as well as prohibits employers from asking job applicants to disclose any arrest that did not lead to conviction. However, this law does not apply to police or other law enforcement positions, as law enforcement agencies are authorized to ask applicants about all arrests, whether or not they led to a conviction or not. Now, under New York Correctional Law, Article 23A, employers are expressly prohibited from making employment decisions based upon an individual's criminal conviction record, unless there's a direct relationship between one or more of the previous criminal offense or offenses and the specific employment position sought or held by the individual, or the hiring or continuation of employment of the individual would involve an unreasonable risk to property or the safety of welfare of the specific individual or general public. For example, if a job applicant was convicted of reckless driving and the job that the applicant has applied for would involve considerable driving, that would be a close enough relationship to deny employment on that basis. The second exception, unreasonable risk exception, tends to hit violent felons the hardest, as many employers will require a job applicant with a prior violent felony to prove that they are no longer a threat to society. When a private employer relies on the unreasonable risk exception in determining whether to grant an employment to an ex-offender, the employer must consider 8 factors that are included in the statute before making any decisions. An employer cannot simply presume an unreasonable risk exists. Employers must consider each statutory factor and cannot ignore evidence favorable to the applicant. Similarly, an analysis of a direct relationship also requires that the private employer analyze the 8 factors to determine if, notwithstanding the existence of a direct relationship, it should, in its discretion, approve the employment sought. New York City Fair Chance Act. In New York City, the laws are even better for employees. Under the New York City Fair Chance Act, more commonly known as Bandbox Law, New York City employers with at least 4 employees are prohibited from inquiring about a job applicant's criminal history until after a conditional offer of employment has been made. An employer may not inquire about an applicant's criminal history or request permission to run a criminal background check until after the employer makes the applicant a conditional offer. Employers also cannot make an inquiry or explore information about pending criminal charges before a conditional offer of employment is made. Further, an employer can never require an applicant to disclose, nor may it consider, non-convictions such as criminal accusations that were terminated in favor of the applicant, were adjudicated as a youthful offender, or resulted in a sealed conviction. Job interview questions outside of New York City. One of the most common questions we receive from clients regarding criminal conviction discrimination is whether it is illegal for an employer in New York to ask about an arrest not followed by a conviction, such as acquittals, declines to prosecute, and voided arrests. Unless the criminal charges are still pending, it is illegal under New York law to ask about an arrest that did not result in a conviction. It is also illegal to ask about juvenile delinquent and youthful offender adjudications, and sealed convictions, including violations, infractions, and misdemeanors and felonies sealed under the conditional sealing law included in the 2009 Drug Law Reform Act. Now, there are exceptions to these limitations on conviction-related questioning in job interviews. Certain employers are allowed, by law, to ask you any questions they want about past convictions. In general, law enforcement agencies, federal government agencies, and the Port Authority may ask about any convictions and can even ask about sealed convictions. For these jobs, you must list any arrests that you are asked about, including those that did not result in a conviction. What information do I have to give employers after a conditional offer of employment is made? Except for what was mentioned previously, an employer in New York can ask you about any conviction that you may have as long as the convictions are not sealed. You are under an obligation to provide truthful answers to the employer's question about your past convictions. Lying during a job interview can be an independent reason to legally not hire you, even if the question is about past convictions. That is because in order to be protected by New York State anti-discrimination laws, you must disclose any unsealed convictions if an employer asks about them. Keep in mind that because you will not receive protections from the New York law if you lie during your job interview, you should study your criminal record to make sure that you know what convictions you have. It is quite uncommon for people with criminal convictions to believe incorrect information about what your information about your criminal record contains. You should request a copy for yourself to review. The most common types of criminal conviction discrimination. Criminal conviction discrimination takes many forms, but occurs most often during the hiring process. Some examples of this type of illegal discrimination include asking the potential employee during the interview or on the employment application whether he or she has been arrested. Now, questions about pending criminal cases are permitted. The other reason is refusing to hire the person due to a prior arrest, even though it did not result in conviction. Denying the position solely due to them having a criminal conviction. And lying to job applicants about their rights as someone with a criminal conviction in the hiring process. Signs of criminal conviction discrimination. Smoking gun evidence of employment discrimination is very rare. Most employers who intend to discriminate will often be good at hiding any evidence, and employers who do not intend to discriminate but do so anyway will be unlikely to leave a large amount of evidence. With that said, once you understand the signs of possible criminal conviction discrimination, you will be able to spot it in the hiring process. If you suspect criminal conviction discrimination, you should look for the following signs. Biased statements about people with convictions. Look for derogatory comments about people with criminal convictions during the interview process. Similarly, situated comparators. Now, a comparator is someone who is in a very similar situation to you, but with an important difference. The fact that one of two similar persons was treated differently than the other can serve as evidence of discrimination. For example, if 3 individuals apply for 2 open job spots, and all 3 applicants are identical except for one with a criminal conviction, a situation where the applicant with the conviction is not hired could evidence illegal discrimination. Now, what do you do if you suspect criminal conviction discrimination in the hiring process or at work? Your first step should be to consult with lawyers that litigate employment discrimination cases to determine if you actually have a criminal conviction discrimination case. Meeting with an experienced criminal conviction discrimination attorney for a free consultation can help you understand both the nature of your convicted criminal discrimination case and the legal options available to you. If you have a criminal conviction discrimination case, you need to start collecting and preserving evidence. To better understand how to collect evidence, you should first know what to look for. If you were denied employment, request a letter from the employer stating why you were not hired. In fact, Section 754 of the New York Correction Law states, at the request of any person convicted of one or more criminal offenses who has been denied a license or employment, a public agency or private employer shall provide within 30 days of a request a written statement setting forth the reasons for such denial. If the excuse does not hold up under scrutiny, that could indicate a discriminatory motive. Document any statements made by the employer related to your conviction. These statements can include offhand comments about people with convictions or may be hidden code words. If the statement comes in written form, such as in a letter or an email or text, keep it. If the evidence is based on oral statement, do your best to remember it word for word and write it down as soon as you can. The best practice in such a situation is to type the statement electronically in some form that has a timestamp, such as a text message, so your attorney can prove the time and place in court if and when necessary. Photograph any images or displays that indicate possible criminal conviction discrimination, such as cartoons about criminals. These are important ways to document evidence. Also, check for past records of discrimination and ask your coworkers about your employer's discriminatory tendencies. Chances are you are not the first victim of the criminal conviction discrimination in the place of employment, and it'll happen again. Review and photocopy any relevant personnel policies. If your employer did not follow an applicable policy, it may be evidence there was an illegal motive. Contact other witnesses and take statements. Make sure to preserve any evidence you have. Keep multiple hard copies in different places in case you lose one. Also, keep an electronic copy safe in a backed up file. Federal laws limiting criminal conviction discrimination. There are no current federal laws that explicitly prohibit employment discrimination based on a criminal record. But as we are in New York State has plenty of good laws that will protect those with criminal convictions. The intersection of race discrimination and criminal conviction discrimination. Under Title VII of the Civil Rights Act of 1964, an employment hiring policy that results in racial discrimination is illegal even if the policy was not intended to discriminate. This is known as disparate impact discrimination. Disparate impact discrimination occurs when an employer's policy, even though it does not address race, national origin, religion, gender, age, or disability, results in discrimination against one of those groups of people. For example, a workplace policy that requires a minimum height for employees may be illegal discrimination against women, because statistically women are, on average, shorter than men. All disparate impact analysis for race discrimination are fact-based. In order to determine if an exclusionary policy has a disparate impact on individuals of a particular race, statistics need to be shown to show that there's a hiring disparity. Without statistics, there will not be a case. However, in some cases, it may be the result that statistics will be just enough to prove that there is such discrimination. There is a guidebook published that allows employers by the EEOC to follow the guidelines of what is disparate discrimination and what questions can and cannot be asked during the interview process for criminal conviction backgrounds. If you have a criminal record, do not lose hope that you will be treated fairly by employers. But if you have been stigmatized by your prior conviction in the job market, you should contact an experienced employment discrimination attorney to determine if you have a legal claim. The law office of Uri Moshes is a full-service employment law firm with offices in New York City and New Jersey. We offer white glove customer service to all of our employment discrimination clients and all of our clients. This means that we will never stop fighting for your rights. We offer free consultations to all victims of employment discrimination. Now, disclaimer. This information is not to be construed as legal advice. Every case is different, and we cannot provide legal advice without an in-office consultation. This video should only be utilized as basic information about New York State law. Additionally, subscribe to our video channel and newsletter. Every week we do produce interesting content covering different issues of labor and employment law.